Hello everyone. Today we are going to talk about is marriage a fundamental right in India and what are your rights? So let's begin with it. Constitution on the issue of marriage. The right to marry is derived from the broader concept of right to life and personal liberty guaranteed under Article 21 of the Constitution of India. While the term marriage is not explicitly mentioned in section Article 21, but the right to marry encompasses various aspects such as freedom to choose one's life partner, the freedom to enter into a consensual marriage, and the freedom to have a meaningful companion. It also includes the right to choose the religious caste or community of one's spouse. These rights are protected under Article 21 as part of an individual's right to autonomy and privacy and dignity. It is important to note that the right to marry is subject to reasonable restrictions imposed by law. These restrictions are primarily based on considerations of public order, morality, and the interest of individuals involved. For example, restriction may be imposed to prevent child marriages, polygamy, marriages that are forced or coerced. Now, what can be your rights? In India, the rights of citizens to marry someone is governed by various laws and regulations. The main legislation that addresses marriage in India is Special Marriage Act 1954 and the Hindu Marriage Act 1955. These laws define the legal requirements and procedures for marriage and provide certain rights and obligations to individuals. Age. The legal age of marriage is 18 years for female and 21 years for male. Marriage involves minors are considered illegal. Consent. Both parties must provide pre-informed consent to enter into a marriage. Forced marriage or marriages without the consent of one or both parties are not legally valid. Now, second is monogamy. India law recognizes monogamy, which means a person can only be married to one spouse at a time. Polygamy, the practice of having multiple spouses, is prohibited, except for Muslims who are governed by their personal laws. Interfaith and intercaste marriage. Indian citizens have the right to marry someone from a different religion or caste. The Special Marriage Act provides the same framework for the interfaith and intercaste marriage, allowing the individual to solemnize their marriage irrespective of their religion or caste or background. Now, the last one is registration. Marriage registration is not mandatory in India but is highly recommended. It provides legal recognition to the marriage and serves as the evidence of the marriage relations. Many government benefits and entitlements are linked to the registration of marriage. Now the next topic is interpretation by Supreme Court. The Supreme Court has consistently held that the right to marry is a fundamental right protected under Article 21. In the landmark case of Saquib versus Union of India, the court affirmed the marriage is fundamental right and stated that right to marry a person of one's choice is integral to Article 21 of the Constitution. The Supreme Court has also emphasized that the right to marry extends to all individuals regardless of gender, sexual orientations. In the historic judgment of Navtej Singh Johar versus Union of India 2018, the court decriminalized consensual same-sex relationships and recognized the rights of the LGBTQ communities to marry. Additionally, the Special Marriage Act 1954 provides a legal framework for interfaith or intercaste marriage in India. It enables individuals from different religion or caste to marry each other without converting to the religion or their faith partner. This legislation is designed to protect and promote the right to marry without facing discrimination based on the religion or caste. Furthermore, there have been several cases where the Supreme Court has emphasized the importance of right to choose one's life partner and have that falls within the realm of personal autonomy and freedom. These include cases such as Lata Singh versus State of Uttar Pradesh, which dealt with intercaste marriage, and Safin Jahan versus Ashokan KM 2018, which address the issue of interreligious marriage. However, the fundamental right to marry is in India not explicitly recognized under a single case, but is derived from the various constitutional provisions, including Article 21, right to life and personal liberty, Article 19, right to freedom of speech and expression, assembly, etc. Now, the conclusion of this is, while there isn't a single specific case that establishes the fundamental right to marriage in India, it is derived from the interpretation of various constitutional provisions, including Article 21 and 2019. The Supreme Court has consistently recognized and upheld the right to marry as an integral aspect of individuals' right to life, personal liberty, and personal autonomy. The right to marry is considered a fundamental right in India and protected by Article 21 of the Constitution. It encompasses the freedom to choose one's partner, enter a consensual marriage, and have a meaningful companionship. The Special Marriage Act further ensures the protection of the marriage without discrimination based on religion or caste. Thank you.